All right, thank you everybody and welcome. My name is Thomas Croessmann. I'm a partner with the law firm of Croessmann and Westburg based in Tysons Corner, Virginia. Our firm is a construction law firm, and so we represent general and subcontractors almost exclusively. So today we're going to be talking about subcontract agreements. Tom, if you can skip to the next page. What good lawyer wouldn't have a nice legal disclaimer? So please take a look at that. But Tom, why don't we go ahead and jump right into it? So before we talk about all these topics, I want to discuss really two important documents that most construction companies should have. The first one being the contract with the homeowner, because that's how you bring in work. And then the second one is, unless you self-perform all of your services, you're likely going to be hiring subcontracts. And the subcontract agreement is going to dictate that relationship and who is responsible for what. So the goal of this presentation is to give you a 10,000-foot view of some of these key terms and discuss what they say. If you might see them, then you can realize what risk you may be taking as a general or as a sub, and whether you'd want those terms in your subcontract. So Tom, if we can skip to the next slide. The first place to start with is how is the contract even going to be interpreted? If you have to enforce this in some type of hearing like court or arbitration, what is the person going to be looking for who's going to make that decision? Well, many states apply what's called the objective theory of contracts. And that's basically, they're going to interpret it as it's written. If you have some special interpretation of a specific word, unless you write that into the contract, it's usually not going to be brought to the court's attention, and they're just going to use the common vernacular to interpret that contract. So it's very important that when you write these contracts, you write them clearly so that your intent of what that contract should be saying is already laid out in the contract itself. Can we go to the next slide? So the first real area that I want to talk about in the subcontract agreement itself is the scope of work. And this is something that I tend to see gets not looked at very closely from both sides, both subs and generals. But it's very important for both parties to really go over the scope of work together. They need to really understand what is the subcontractor's responsibility to perform. And then on the flip side, whether the subcontractor can actually perform that work. Places where you see contracts being written very broadly, and it's because usually the sub doesn't review it very closely, is this general will include very broad language like the sub will do all work needed to complete the task. And all work needed is a very broad clause and can encompass much more than the sub originally intended to bring on. So it usually is a good thing for the subcontractor to really go over the scope of work so that each party is very clear on what their obligations are. A lot of the times we see scopes of work as attachments, so they're just on the back. Usually you'll have like a long sheet of general terms and conditions, and then it'll say the scope of work is an attachment A. Let's go ahead to the next slide. The next thing is you want to talk about, or your subcontract should have some kind of schedule in it. Now, I list 3 different types of scheduling that you typically see. In the residential world, you really see more of the first, full days, half days, maybe a week. And that is fine, but you really want to establish, okay, what is the schedule for my sub to do this amount of work? And can they do it in that amount of time? So the other ones, bar charts and critical path method, those are specific methods that are typically used in commercial or government contracts. I'm happy to talk more about them. If you have questions, we can do that offline. They're usually required for much bigger jobs, but again, from what we typically see on the residential side, it's usually more of a full day, half day, week type schedule. But we really focus on schedules a lot because from a general's perspective, a general contractor's perspective, you can look at your schedule and see if your project's going off the rails very easily by just simply looking at the schedule. So we always encourage everybody to really keep track of that and update your contract schedule as needed. The last point here talks about the schedules are particularly important if your contract, the general's contract with the owner, has what's called liquidated damages that we'll talk about down below. But just keep in mind as we talk about it that it relates back to schedule, and I'll make sure to come back to it. The next slide, please. So we just talked about scheduling and why that's important, but a clause that we see a lot is something called a no damages for delay clause. And that is essentially a clause that waives the subcontractor's ability to recover damages from the general contractor due to any project delays. So let me give you an example of what that might look like. So if the general contractor messes up or other trades are running behind on their schedule, and you're the sub supposed to work from Monday to Friday, but you can't get in there on Monday because either other trades are in the way or the project site's not ready, and that pushes you several weeks out, well, that's going to have an impact on your business and maybe even the cost for you to perform this. So you would try normally to go and recover those damages from the general contractor. This clause, if it's in there, will prevent you, the sub, from recovering for those delays. You wouldn't get any damages. You may get the extra time to complete the project, but not the actual money from it. These clauses are generally enforceable unless there's the general exceptions are if there's any intentional interference by the general contractor, if they're specifically stopping you for some reason from going in there, if there's fraud, misrepresentation, or gross negligence. But that's a clause that you would really want to look out for because it has a great impact from the sub perspective on whether you can recover for those delays. I prefer if people ask me questions when they have them. So I see that we have a question. It says, how, as a contractor, deal with a clause when the homeowner wants to add it? Trish, if you could explain that a little bit more. I'm not sure. Are you talking about the no damage for delay?
Yes, I'm talking about the no damage for delay because we like all of a sudden perspire and get the shakes when a client wants to add this, time for damage for delay.
So that's a little outside the scope of this because that's between the homeowner and yourself.
Okay.
We'll talk about it with you. This presentation might answer some of that, but a lot of it just comes down to bargaining power. Generally speaking, our position is, you want to get, if there's a delay, you want to be compensated for it. So be careful when you sign those provisions to make sure that there's not a no damage for delay clause.
Mine was more the client wants to have money damages to them if we're delayed.
Liquidated damage. We'll talk about that later on in this presentation. Again, we'll talk about it. I might be able to answer your question. If I don't, then we can talk about it offline. All right. Tom, can we go on to the next slide? So the next one that we're going to spend a little bit more time on than the other ones, because the other ones we kind of went through quickly because while they're very important, most of the time they're pretty clear cut, except for the no damages for delay clause. The one where we see a lot of disputes is regarding payment terms. And there's two general types of payment terms that we're going to be talking about here. And that is what's called the paid if paid clause and a paid when paid clause. And we're going to talk about those differences now. The paid if paid clause makes the owner's payment to the general contractor a condition precedent on the general contractor's obligation to pay the subcontractor for their work. So what does that mean in real English? It means if I'm the general, if I don't get paid by the owner, I don't have to pay the sub, and the sub can't sue me to recover if I have not recovered from the owner. So what would a real life example look like? If I'm the general contractor and I have a homeowner who owes me $100 and I hire a sub to do that work and I'm going to pay that sub $90, then if everything goes well, I'm supposed to make $10. A homeowner is going to give me $100. I'm going to give $90 of that to the sub. Now, the reason this paid if paid clause was even created is to help the general contractor with cash flow. So if there's a paid if paid clause in the subcontract, what that allows the general contractor to do is if I don't recover my $100 from the homeowner, I don't have to pay the sub the $90. It shifts the risk from the general contractor to the sub for non-collection. And a lot of people come to me and go, that's really unfair, Thomas. And you know, that's fine. It can be. You know, we represent subs where that's been the case, and it certainly hurts. I'm not going to lie. But it's made to prevent the general from being in this scenario. So if you don't have a paid if paid clause, you don't recover the $100 from your homeowner. So now you, as a general, are out $100. But then you're also obligated to pay $90 to the sub. So now that general is really out $190 instead of making the $10 that it was originally planned. And so that's why these clauses even exist. Now, they are enforceable in most states, but the courts don't really like them because it obviously has a very heavy hammer on the subs. So they make sure that if they're going to be enforceable, they have to be clear and unambiguous, and they usually have to state that payment by the owner is a condition precedent for payment to the subcontractor. They usually require those terms, condition precedent. And so what happens if you don't write it accurately? They won't enforce it. And what it does is makes that paid if paid clause what's called a paid when paid clause. Tom, can you go to the next slide? And that's what we're going to talk about now. So a paid when paid clause just says, it reads very similar, and you really have to kind of find the technical words in there to make sure you know whether it's paid if paid or paid when paid. But what a paid when paid does is just says, I'm going to get paid, the sub, I'm going to get paid by the general when the general gets paid by the owner. However, instead of that obligation being a condition precedent, it just becomes or a reasonable time. So going back to our example, if I'm the general contractor and I'm owed $100 from the homeowner, and there's a paid when paid clause in my contract with the sub, I may not have to pay them immediately, but at some point I will. And the courts usually interpret these clauses to say a reasonable amount of time. Now, what does that mean? Well, that's up to litigation to fight over, but it doesn't relieve the contractor of the obligation and its liability to the sub. So what you typically see is failed paid when, if paid clauses become paid when paid clauses, and those lawsuits do move forward. So on the defense side, like when we're representing the subs, we try to look to see if a paid if paid clause was written correctly, or can we make the argument that it's actually a paid when paid clause. And these are very important. Again, they're all kind of geared towards cash flow. Anybody have any questions at this point? All right, Tom, can we go to the next slide? So another one that we're going to talk about is retainage. Now, you see this a lot in commercial and government contracts, and we're starting to see them more on the residential side. But retainage is when a subcontractor has done work, the general contractor is going to hold back a percentage usually. Usually it's like 10% of a payment to make sure that that subcontractor finishes the job. Where you see this a lot is if there's a lot of different partial payments being made or progress payments, they would hold back 10% of each payment, and then the sub would get that back at a specified time. An example of the language would be something like, retainage will be withheld of 10% per payment until the owner accepts the final product of the job or when the project is completed. Now, why does that matter? Well, it's all about timing of when the sub is going to receive that. For example, if you're a demolition company and you're going in there, you're the first one in, you're first one out. If you have a clause in your subcontract that says that you're not going to get paid until the job is complete, you may be waiting many months or maybe even years until the renovation is complete or the building is built to get your retainage actually back. And so when we look at subcontracts, those are the things we focus on depending on the particular trade that our subcontractor does. Demolition company is a great example, usually because they are the first ones in or first ones out. So in that situation, we would try to go back and say, you can withhold retainage, but as soon as they've accepted our part being complete, for example, the demolition is completed correctly, that's when the 10% retainage would be returned to us. The other thing is, you really want to keep in mind, if you're doing any kind of settlement, if there's a dispute that arises between the general contractor and the subcontractor, you want to keep in mind if retainage has been held, because you may be waiving your retainage without even really knowing it. For example, if I'm a general contractor and I'm in a dispute with a sub over payment, I may say, yes, I owe you $100, and then I technically owe you another $10 for retainage, but I think you did something wrong, or for some reason I'm not paying you. I'll offer you $90. Well, if they accept that $90, they may be leaving that retainage back to the general. So whereas they were supposed to receive $110, they've now only received $90 and taken both a loss on the initial amount that's owed, but also the retainage that was withheld. So you always want to make sure that when you're doing that and you're settling, does this include our retainage, or am I still going to get the retainage back after this time period has ended? Tom, can we go to the next one? So notices and changes. This is all about change orders and who do you tell if you come across something that is outside your scope of work, or it's an unforeseen condition or a differing site condition. This section or clause will tell you exactly what your obligations are. I will tell you, this is where we see a lot of contractors lose their rights, is in the notice and change provisions. The courts do strictly interpret these provisions for compliance. So for example, if your clause says, if you come across something that is a change from the scope of work as a sub, you have 24 hours to notify the general. And or else, if you don't notify us, it'll be deemed waived, and that additional work will have been deemed to be within your original scope of work. So there's a lot of bad things that can happen to the sub if they're not really aware of this provision. And as it says, failure to follow this provision is the fastest way you lose your claim. We see that all the time. Most of the time when we see these clauses, they require that the change is put in writing and is given to a particular person. And they usually have some very short time frame. They'll either say immediately or within 24 or 48 hours. And they require a certain level of detail, and they may require you to put a cost estimate and a time estimate in that change. So those are things that you really want to watch, because again, if you don't tell them, you may be waiving your claim. And the logic behind it is, as the sub, I have to give the general notice and in a specific enough time so that the general can go to the owner to try to get a change order. So depending on your general and your homeowner relationship, if your homeowner contract says that you're going to give a specific amount of time for changes, if you find a differing site condition, you usually will require the sub to give it to you even faster. So if your contract with the homeowner says, if we find a change, we're going to notify you in 5 days, then you would say something like to the sub, you need to tell us of change orders within 48 hours, because we need the extra 3 days to look at it ourselves, maybe add a markup on it, do anything else the general needs to do, and then to present it to the homeowner for approval or disapproval. Tom, can you go to the next slide? I think you skipped a slide. There you go. So liquidated damages. Trish was talking about this a little bit, and we talked about it a little bit in schedules. So a liquidated damages clause is a predetermined amount of money that's paid if you don't complete the job on time. An example would be the owner is going to charge the general contractor $100 every calendar day that they go past the date listed in the contract. And those are enforceable, by the way. But the liquidated damages are designed to be the party's best estimate of each side's damages at the time that they're signing the contract. So why is that important, that for subcontracts? Well, because usually what the general does is if they have one of those in their contract with the owner, they will try to pass it through to the sub. And this is where, from the sub's perspective, you really want to look at your schedule. Can you do it in that time? If something happens, I need to know what my notice provisions are for any changes, because I might be hit with these liquidated damages, which either are equal to or could even exceed the amount that the owner is going to charge the general contractor. So it's very, very important for subs to really analyze, can I do the job in this amount of time? Because if I don't, I'm going to have to pay out of pocket to the general to cover their costs to the owner. The liquidated damages, the only way that you can really fight them is if if a court finds that they're a penalty, then they won't be enforced. But generally speaking, they are enforceable and they can be very dangerous. You need to know where the parties' powers are in that relationship for the negotiations to know whether you can get that clause removed or not. 9 times out of 10, if the owner is requiring the general to pay liquidated damages, the sub is probably going to have to pay liquidated damages if they run over. But that's why those notice provisions that we just talked about can be so important, because if you put in a change order and you get additional time, that gets added on, and now you're not being charged liquidated damages. So really got to watch that. We don't see a ton of this in the residential world, but we do see them in the commercial world a lot and in the government contracting. So if your company does both commercial and residential, you really got to watch yourself, because you might be unexpectedly walking into a situation where you're going to be responsible for liquidated damages. Tom, can we go to the next slide? So termination for default. These provisions are good just to clarify exactly what is a default, under this contract. And you can define it in a lot of different ways, however you feel it protects you or not. And then, is there a notice provision? For example, does the general contractor have to give the subcontractor notice that, hey, you're now in default, you have done something wrong? And then is there a cure period? Does the sub get 5 days, 10 days to cure that default and keep them from being terminated? So why is being terminated so bad? Well, typically the subcontractor is still on the hook to finish the job. So if they get terminated for default and the general goes out and hires somebody else, it's likely that the new contractor is going to be more expensive than the original sub. And so the sub that was originally terminated is going to have to be responsible for that new contractor's cost. The way that the general pays for that is usually by withholding all funds that's due to the subcontractor and using that as an offset. So if I owed my sub $100 and this new person comes in and I have to pay them money, I'm not going to pay my initial subcontractor the $100. I'm going to pay them the difference, if any, is left over after I've paid the new contractor to finish the job. Again, here's another situation where you got to watch for retainage, because if any retainage was withheld, that will also be used to help offset those costs. Tom, can we go to the next slide? I think you skipped one. Yeah, termination for convenience. So we've talked about what's termination for default, and sometimes you'll see what's called termination for convenience. And this is the sub, you didn't do anything wrong, but for some reason, we the general are terminating the relationship. A couple of examples would be if maybe you found a cheaper subcontractor to do it, or if the owner canceled the contract with the general, then the general would cancel the contract with the sub. And what's important about this clause is it determines the rights in what happens in that situation. So, are you going to get time and materials for any unresolved change orders? Are you going to get anticipatory profits? So I expected, as the sub, I expected to get $100 in profits. Do I get that if you terminate me for convenience? And this is where that bargaining power between the general and the sub is going to come into play, because sometimes they'll say, no, you don't get any anticipatory profits. Sometimes you can get anticipatory profits. And so that needs to be all laid out if you have a situation like that. The other thing that is typically included in a termination for convenience is if you are terminated for default and then you go to court and the judge says, no, I don't think there was a default, it usually allows the general contractor to say, oh, we actually terminated you for convenience. It actually wasn't for default. But then all of these other provisions apply, like anticipatory profits. How are you dealing with unresolved change orders? So very, very important things to have. Tom, can we go to the next one? So indemnification. Indemnification is something that is almost universal in all subcontracts. A lot of the stuff we've talked about, you may see, you may not see, but indemnification is, again, almost universally seen. So what is indemnification? It's basically a clause that says, I, the subcontractor, am going to hold you, the general contractor, harmless if I screw up and you get sued. So the typical way that we see indemnification enforced is homeowner sues general contractor for something that the sub did. And then the sub has to either pay for the attorney to defend the general contractor, and or pay for any damages that the general contractor has to pay to the owner. So typically what you see is that the general contractor writes these terms very broadly because they want as much protection as they can. And then the sub comes in and tries to narrow that down to only specific things. An example would be a general might say that you're gonna indemnify us for all work and related work, or associated work that could be related to your work. Well, that's really broad, and so you want to narrow it down to, I'm only going to indemnify you if the specific things I did are wrong. So this is, again, talking about the bargaining power between the two parties. Tom, can we go to the next slide? So another thing that we see a lot in is warranties. And this is just, what you would expect. How long is the sub going to give me a warranty for their work? Are there any exclusions that I need to be aware of? The reason that warranty provisions are really important in a subcontract agreement is because the general contractor tries to mirror what they're giving to the owner in their subcontract. So for example, if the general contractor is saying, I'm going to warranty to you, owner, I'm going to warranty all of our work for 3 years. Well, generally speaking, you want your contract, your subcontract between the general contractor and the subcontractor to also be for 3 years, because otherwise you could have a gap. If your contract with the sub only says you're going to give me a 2-year warranty and I give a 3-year warranty to the owner, now the general is going to be on the hook for a year gap of warranty. The other thing you need to watch out for is whether there's going to be any retainage for warranty items. So we're talking about the same thing that we talked about earlier under the payment terms, which is retainage. It's an amount that's withheld per payment, but this is done to ensure that no warranty claims are made. And if a warranty claim is made, the general has some money to then use to fix that. And the warranty retainage is usually paid back at the end of the warranty period if no claims are made. And that can be a big deal, because if you're giving a multi-year warranty, you may be out 10% or so, or 15%, whatever you're negotiating. and they're going to be waiting a long time to actually receive that money. And if there are claims made, then the general is going to use those funds. And sometimes that's a lot for a sub to bear, because that could be their entire profit margin. So we just had another question come in. Most residential subs will not honor their warranty unless their original agreement has been paid. Well, that's why you need to have that laid out in your subcontract agreement. Is we are allowed to withhold this warranty retainage, and then if they don't honor it, you sue them under the subcontract for not honoring their warranty. So that's why these things are really important. A lot of people come to me and they say, "Hey, Thomas, I've had this sub I've been working with for a long time, and we just do handshake deals." And I'm not going to tell you that's wrong, but you do lose a lot of potential bargaining power when you do that, because questions about warranties are always at issue if there's any exclusions, and what are the rights of the parties. So we just had another question come in. It says, what are you finding these days for the length of a residential remodeling warranty time period? We usually see 2 years. That's the typical standard, if I had to guess. Sometimes it's longer. If you're doing roofing and siding work, we'll see 10 years or longer. But for most remodeling, it's usually a year or two. Tom, can we go on to the next one? So this is the last slide, because I wanted to leave time for questions, because we did go through a lot of terms. I tried to go through them quickly, but if you have any more questions, please let me know. So the last thing you want to have in your subcontract agreement is something that deals with disputes. So if you and the sub go and have a dispute, how is that going to be handled? Are you guys going to go to court? Are you going to go to an arbitration? Are you going to go to a mediation? Are you going to do it in a specific venue or jurisdiction? Is it going to be Virginia? Is it going to be Maryland, DC? The one thing that's not on here that I do want to talk about is specifically attorney's fees. In the United States, we follow what's called the American rule, which is basically says unless you have a written contract or there's a specific statute that allows you to recover attorney's fees, each party has to pay their own attorney's fees. Now, that can be a very big deal, because sometimes if you have a small claim, the attorney's fees can be more than the claim amount itself. Or if you have a large claim, the attorney's fees can be quite large. $50,000 if you go through circuit court, or even more depending on the complexity of the case. So if you don't have a written contract with your sub that lays out that I'm going to be entitled to attorney's fees if I have to bring a dispute claim against you, sub, then if you sue that sub, you're going to be responsible for all of those attorney's fees out of pocket. So when those handshake deals happen, you're not getting attorney's fees 9 times out of 10. And the same thing goes for expert witness fees too. So if you have a complex case where you need to bring in an outside expert, in your subcontract, you can dictate who's going to pay for those. And that's another place where you have bargaining power, that you can talk about how you're going to phrase that. It may be that you have a clause that says the general contractor is entitled to the recovery of their reasonable attorney's fees and expert witness fees. Or it may be something like the prevailing party. And so it could be either side, the general or the sub, could be entitled to attorney's fees and expert witness fees. It just depends on how you draft it. But again, if you don't have that in your subcontract, you're generally not going to be entitled to recover your attorney's fees. Anybody else have any questions? I know I went through that kind of fast. I wanted to, again, it's mainly geared to cover the 10,000 foot view of what to keep in mind when you're looking for subcontracts. A lot of people come to me and go, Thomas, you just covered a whole lot of stuff. Who would ever sign an agreement that had those things in it? From our experience, about 95% of the time, subs sign contracts that have all of these provisions in it. And that's the simple reason is because If you don't, then the general will just move on and find another sub who will. And it's all about protection for the general. And so it's really important for the sub to really keep an eye on all these clauses so they know exactly what they're signing. I have a lot of situations where we'll go after a sub for a general, and the sub will say, I had no idea that any of this stuff was even in there. It's like, well, yeah, that's why it's really important to read it. But so if anybody has any questions, please feel free to email me or call me. But other than that, does anybody have any questions? All right.
I have a quick one. How often should we have our attorney review our contract?
So I would, there's a couple of things. I mean, number one, generally speaking, I would say annually or every 2 years would be a good, just if you have no problems, a good time to do it. Just as a refresher to see if there's anything else that needs updating. Where we also see it is if we have an actual problem, right? Where you have a sub that has done something wrong, and your current contract doesn't really address it. That's when then you come back and you say, okay, we need to talk about this. We need to get this fixed. An example would be the attorney's fees. You know, if you have a contract that doesn't have anything about attorney's fees and then you have to sue your sub, then you have to, you won't be entitled to the attorney's fees. So that can be a lot of out of pocket. So that's why then you go back and you modify your subcontract agreement to include those types of provisions.
Thomas, I think Tricia had another question there about employee handbooks.
Yeah, so we do work with employee handbooks. So if anybody has questions on those, I'm certainly happy to talk about it offline with you. Those are more geared towards obviously the employees and not any 1099 or subs, but we can certainly help you with that. We are a full service law firm when it comes to contractors. We help them in all aspects of their business. The only thing is, don't come to me for a divorce. We don't do family law stuff. So child custody, divorces, alimony, we don't do any of that. But everything else we pretty much do.
All right. Well, Thomas, thank you very much for the great information and being a great partner with NARI DC. We certainly do appreciate it.
Yeah, absolutely. Always happy to help and very glad to be part of it.
All right. All right. Just a couple housekeeping issues for everyone else. Again, thank you to all of our sponsors that we've recognized throughout the Education Day. Another quick reminder.